Hello friends, welcome to my channel. My name is Sushma. Today I will be studying the Criminal Procedure Code 1973. To understand, let us understand few important basic points. That is the term law. Law has been defined by various institutions and scholars from time to time, and there is no specific definition for the term law. So I have chosen two simple definitions to understand the term law. So law is a system of rules which are enforced to a set of institutions, and there are uniform rules which regulate human behavior are also called as laws. So there are many kinds of law, that is specific law, general law, civil law, criminal law, public law, private law, national and international law, statute and common law. So today we'll be understanding the two most important classification of law is substantive law and procedural law. So substantive law define an offense and prescribe punishment for the offense. The punishment may be of two, that is penalty or imprisonment. And in procedural law, it governs the way in which substantive law are to be administered. Procedural law is also called a subjective or remedial law. The second point is the substantive law determine the rights and liabilities of the parties. For example, suppose a person has been arrested. He has right to know why he has been arrested. He has right to call an advocate. He has right to apply for a bail. Depends on the nature of the offense. So in procedural law, it prescribe the practice and procedure and machinery for enforcement of those rights and liabilities. It prescribes how the bail has to be applied and what are the conditions for the bail. The third point is substantive law define what people can and cannot legally do. So for example, a law prohibiting driving more than a certain speed. We have come across such signboard stating not more than 40 km per hour, not more than 60 or 70. Okay, in procedural law, it established a procedure used to enforce and apply other laws. For example, a law stating how evidence should be collected in a criminal case. Another example, suppose a person has trespassed a property and has committed a theft. Trespass comes under the civil wrong, and theft comes under the criminal wrong. So both the cases will be combined and tried by the court. Okay, now let us see the substantive law that comes under the substantive law. There are Indian Penal Code 1860, Indian Contract Act 1872, repeal to 2013, Transfer of Property Act 1884, the Drugs and Cosmetic Act 1940, the Prevention of Food Adulteration Act 1954, the Essential Commodity Act 1955. These are the few examples that I have stated for the substantive law. There are many other laws that comes under the substantive law. And for the procedural law, Indian Evidence Act 1872, the Limitation Act, the Code of Civil Procedure 1908, the Code of Criminal Procedure 1973. Now we have understood what is substantive law and the difference between the substantive and procedural law. There is an important point to be noted down, that is a procedural law is always subservient to the substantive law. That means it goes hand in hand undoubtedly. So for example, suppose there is a murder that happened, but what exactly is a murder as per law, what its punishment, all this we find in IPC, which defines murder and prescribe punishment for the same. This is substantive law part. And coming back to the procedural law, a person has to file an FIR in a police station, after which the police will arrest the accused. So why you filed an FIR, how the FIR will be filed, how many witnesses are required, all this is prescribed in CRPC. Later, how police will arrest the accused. Suppose it is a female, she cannot be arrested before or after 6 a.m. and 6 p.m. And necessarily that female police constable present while arresting the person. Okay. So the next point is the Code of Criminal Procedure Act, procedural or substantive law. This question has been asked in bar exam, Indian bar exams and judiciary exam. We have already understood what is procedural law and what is substantive law. And we even enlisted in the procedural law stating the Code of Criminal Procedure Act comes under the procedural law. But there are certain provisions that are in nature of substantive law. For example, chapter 4 chapter power of superior officer of the police, aid to the magistrate and police. In chapter 8, dealing with the security for keeping the peace and for good behavior. In chapter 9, order for maintenance of wives, children and parents. And in chapter 11 we find that the preventive action of the police. And then in chapter 34, general provision as to inquiry and trials. All these are in substantive in nature. So the Code of Criminal Procedure Act is not pure adjunctive law. Now let us know the history of the Criminal Procedure Code 1973. So earlier, that is when India came under the dominion of East India Company, Mohammedan or Muslim criminal law was applied both to Muslim and Hindus. There were so many defects in the Mohammedan criminal law with regard to the kind of punishment or law of evidence, and there was no uniform criminal procedure, and hence the code in provinces and presidency towns were guided by separate act relating to the procedure. And for the first time, the laws of criminal procedure were consolidated by the Criminal Procedure Supreme Court Act 1852 applicable to the presidency towns. And the second, later, the High Court Criminal Procedure Act 1865 applicable to the High Courts, and the Criminal Procedure Code 1861 enacted for the provinces. The Criminal Procedure Code 1882 was enacted, repealing the previous acts. This was the first uniform criminal procedure for entire India. In practice, several defects were found in the Code of 1882. As a result, the Code of Criminal Procedure 1898 was enacted, even though there were certain amendments made to it. The major amendments were made to the Code of 1898 in 1923 and 1955. As we all know, the Constitution of India came into force with effect from 26 Jan 1950. The spirit of the Constitution of India had influence for enacting the new Criminal Procedure Code in the place of then existing Code of 1898. So the Law Commission of India submitted its report in 1958, making several suggestions and amendment and recommendation to enact a fresh criminal code suitable for the independent India and applicable to the changed circumstances. So basing upon the recommendation, the Law Commission of India draft bill was introduced in Rajya Sabha on 10/12/1970. Some of the basic and fundamental conditions were fair trial. That is, an accused person should get a fair trial in accordance with the accepted principle of natural justice. And the second is avoid delay. Justice delayed is justice denied, as we all know. So every effort should be made to avoid delay in investigation and trial, which is harmful not only to the individuals involved but also to the society. The third, the most important point is the procedure should not be complicated and ensure fair deal to the poor section of the community. So the Joint Select Committee of both the houses of the Parliament, the bill was referred. Finally, the bill was passed by the Parliament and emerged in its present form as the Code of Criminal Procedure 1973. So the Code of Criminal Procedure 1973 came into force on April 1, 1974. So this question has been asked in bar exam as when did the Code of Criminal Procedure Code 1973 came into force? On April 1, 1973, April 1, 1974, and another one is 10/12/1970. So the answer should be the April 1, 1974. Extent and applicability of the Criminal Procedure Code. It applies to whole of India except Jammu and Kashmir. Provision of the code except chapter 8, 10, 11 shall not apply to the state of Nagaland and to the tribal areas. The expression tribal areas means the territories which are included in the tribal areas of Assam. So the structure of the code. Originally, there are 484 sections and 2 schedules. After the amendments made, there are totally 523 sections and 2 schedules. 39 new sections have been added to the code. Note, the 484 sections remain the same and the new 39 sections are newly incorporated with the suffix of A, B, C and so on. For example, in the chapter 7a, the sections 105a to 105l, and in another chapter, chapter 21a, section 265a to 265l have been newly added. Including these two chapters, there are 39 chapters in the code. So the first schedule contains the classification of the offense, and the second schedule contains the various forms required to be used in the procedure of the criminal courts. So I am referring to the Bail Act. This is how the Schedule 1 will be. Schedule 1 classifies all the offences defined by the Indian Penal Code into the bailable offence and non-bailable offence, cognizable and non-cognizable, the particulars of the punishment, and lastly in which court. So we can see the schedule. It states the offence and it describes imprisonment and states the nature of the whether it is cognizable or non-cognizable, and bailable or non-bailable, and in which court it is triable. So today we have understood the term law, the difference between the substantive and procedural law, history of the criminal procedure code, structure, extent and applicability.